So I want to take it first before we now resume with the physical sitting. Yes, any appearance? Have you given the council the? I can't see them. But they are not online.
Yeah, my lord, I'm here. It's the network. The network is bad.
If I can't see your face, I can't record you. You are absent. You have to make your face available. Otherwise, you are absent. You are not present in court. Don't waste my time. I have cases to attend to. Yes. Parties absent. No legal representation. Give me that. This case is hereby adjourned to 6th of July 2023 for hearing. Who is this? Who is this?
Open is on. Open is live streaming the.
Suit number NICN/CS/33/2020 was called virtually. No parties absent, no legal representation. This case is adjourned to 6th
My lord,
of July 2023
I'm here. The network is bad.
for hearing. I have already adjourned. You can't waste the time of the court.
As the court pleases.
No, that's really.
You said?
That's really.
Which one?
Ruling Lapo.
Yeah, John.
This one you have not given it to me. How can you?
My lord, it was you too. You sent it back to me.
No.
There
was nothing to indicate.
No, I have.
I said there was nothing to indicate on this. That is for real.
I just removed the paper now. Yes.
Another one before the computer.
No, this one too is for the. No, we should call this one.
I say call the other one. Okay. I have to check.
43M.
Suit number NICN/CA 43M/2022 between Mr. Calabar and Idigbe. And
you said who?
Bat.
Is it Bat?
Yeah,
I don't think that is the, I don't think that is the correct pronunciation.
Mr. Bate Idigbe.
He is from here now, so he's supposed to know the name, how to pronounce it.
And 1, the head of civil service, Cross River State. 2, the accountant general of Cross River State. 3, the attorney general of Cross River State. My lord, the claimant is absent. Defendants are all absent, my lord.
Appearance?
Can you please, my lord?
Yes.
Oliver A. San appears for the judgment creditor applicant.
Yes. State Council 1. This matter is for ruling. This is my ruling. This is a motion on notice for committal dated 21st day of November 2022 and filed on the 22nd day of November 2022. The motion on notice was brought pursuant to Order 63, Rule 1, 2, and 3 of the National Industrial Code Civil Procedure Rules, Order 9, Rule 13 of the Judgment Enforcement Rules, and under the inherent jurisdiction of the court. The application is providing for the following orders. 1, an order committing the judgment debtors respondent contemnors to custodial center on such terms as this honorable court may deem fit an expedient to make consequent upon disobeying the order of 3rd day of February 2022, directing them to reinstate the name of the judge day of February 2022. 3, and for such further or other orders as this honorable court may deem fit to make in the circumstances. The grounds for this application were given as follows. I will skip reading the grounds. They are already in the body of the ruling, so council will read when they collect. The motion on notice for committal is supported by a 10 paragraphs affidavit sworn to by the claimant himself. A written address accompanied the motion on notice for committal. Upon being served with the judgment debtors respondents counter affidavit, the judgment creditor filed a further and better affidavit in response to the counter affidavit. Oliver A. Osang Esquire counsel for the judgment creditor applicant in oral adumbrration informed the court that he is relying on the depositions contained in the affidavits filed in support and the further affidavit. Council also adopted the written address filed with the motion on notice. In the affidavit, the judgment creditor applicant stated that by judgment of 3rd day of February 2022, this court ordered the judgment debtors to restore the name of the claimant back to the payroll and pay him arrears of salaries. But the judgment debtors, despite being served with the judgment of the court from 48 and 49 of the judgment and 48, the judgment debtors have failed, refused, and neglected to comply with the judgment of the court. In the written address, a single issue was formulated for determination to it whether this honorable court can grant this application for committal in view of the disobedience of the order made on 3rd day of February 2022, and committee council submitted that the application certain elements which are 1, it must be proved that the judgment debtor had proper notice of the terms of the judgment of the judgment. 2, there must be a positive proof that the terms of the judgment report 2022 as encapsulated in were unambiguous and still subsisting, directing judgment creditor back and restore his name back to the and pay him arrears as salaries. Council continue his submission that the order is clear and unambiguous to so as to the case of a respondent have not denied and cannot deny the ambiguity of the order of this court. We counsel asked the court to find and hold and so hold. It is also order 9, rule 13 of the judgment enforcement rules. There must be proof that judgment debtors respondents have had proper notice of the term of the injunction order for the purpose of amplification. Counsel reproduce the provisions of the said order. I will keep reading the provision. Counsel submitted that the apex court in Yekini, Abbas and others versus Solomon affirmed the above position of the law. It is submitted that the judgment debtors have proper notice of the terms of the order of this court. Counsel refers to the letters he has written, which were attached as exhibit B, C, and D to the affidavit in support. He also submitted that the bailiff of the court, served from 48 and 49, with endorsed judgment stroke order of the court. Counsel refers to exhibit E and F as evidence of that. Counsel also submitted that the rules of this court made adequate provisions for the punishing disobedience of its order, as contained in Order 63 of the National Industrial Code Civil Procedure Rules 2017. Counsel reproduced the said order. I shall also keep reading it. Counsel further submitted that the order was served on the judgment debtors, and there is no doubt that the terms of the said order were unambiguous, and proper notice given to the judgment debtors and the terms of the order have been breached by them. In concluding his submission, counsel asked the court to grant the application and punish the contemnors for their disobedience of the judgment of this court. In response to the application, MB Ewa Esquire State Counsel, appearing for the judgment debtors, informed the court that she is relying on the deposition contained in a 12-paragraph affidavit, counter affidavit, filed in opposition to the motion on notice for committal. Counsel also adopted the written address file along with the counter affidavit. In the affidavit, the judgment debtors denied ever violating or disobeying the judgment of this court, ordering the first and second defendant to reinstate the claimant. They also attach exhibit MOJ1 as evidence of compliance with the order of the court. In the written address, a single issue was formulated for determination to wit whether this honorable court can grant this application against the respondent. In arguing in opposition, counsel submitted that on 3rd day of February 2022, this court did not make any order against the third defendant which he disobeyed and have to be committed for contempt. Also, the second respondent was not served with the judgment order as alleged by the claimant applicant. Counsel argued that committal for contempt proceeding is quasi-criminal in nature. Therefore, the law and procedure are strictly applied, and any slightest wrongful step taken will vitiate the entire proceeding. This is so because it involves the freedom and liberty of a person. In support of this submission, counsel relied on the case of military governor of Kwara State versus Apolabi. He also relied on the case of SAG versus Ike and that of Chief Debia versus Chief Eze Igwe. Counsel further submitted that there is no evidence by proof of service that from 48 and 49 were personally served on the respondents or at all as required by the law. Counsel submitted that non-service vitiates this proceeding as the service of from 48 and 49 are condition precedent for the exercise of the jurisdiction of this court to entertain this application. Therefore, due process to bring this application was not fulfilled. According to this action, this action is incompetent and should be dismissed. On this submission, council relied on the case of Madukolo versus Inkendilim, Ebong versus Epion. Council continued his submission that in any event, even before the purported filing of Form 48 and 49, the first respondent by a letter dated 7th day of July 2023, which was served on the applicant through the Chairman Secondary School Education Board, Calabar, reinstated the applicant in compliance with the order of this court. Applicant, therefore, is not right in the circumstances to apply for committal of the respondent for disobedience of order of this court. It is also the submission of counsel that application to commit for contempt is not made at large, and the order made at the whims and caprices of the applicant. In the circumstances, counsel commended to the court the Supreme Court decision in the case of Abbas versus Yekini versus Solomon, which was also relied on by the applicant, the judgment creditor. Counsel concluded his submission by submitting that this applicant in this case has not satisfied or proved beyond reasonable doubt that the respondents in any way disobeys the judgment of the court as alleged by the applicant. Counsel asked the court to so hold and to accordingly dismiss the application against the respondent. In reply on point of law, counsel mentioned that the order of this honorable court, as made in its judgment of 3rd day of February, was against and directed to all the defendants jointly and severally. All the respondents are liable jointly or severally for any breach of the order. All the respondents were served with Exhibit B as per Exhibit B, C, and D, which are the applicant's counsel's letter of 3rd day of March 2022, 16th day of May 2022, and 5th day of September 2022, respectively, with the attached judgment orders. To each of them, the respondents therefore have adequate notice of the judgment order. Most of the respondents were represented by counsel, and they cannot complain of not having notice of the judgment on terms contained therein. The court's judgment of order, the court judgment of 3rd day of February was served on the judgment debtors through the judgment creditors, applicants, solicitors' letters, including Form 48 and 49, in spite of the service of the court judgment and order letters, and Form 48 and 49, the judgment debtors have refused and failed to pay the orders. Hence, this application, according to counsel, by the deposition 5C of the respondent's counter affidavit, an argument thereto is clear that the respondent are not complaining of non-service but personal service of Form 48 and 49. It is a submission of counsel that the respondent were sued in their official capacity and not personal capacity, and therefore enforcement of the judgment order emanating from the suit cannot be imposed personally against them, but against their offices as key government functionaries. It is further submitted that the respondent were duly served with Form 48 and 49 by the bailiff of this court in accordance with Sheriff and Civil Process Act and the judgment enforcement rules, which proof of service duly filed in the court's file. It is also submitted that the content of Exhibit MOJ1, which is the first respondent letter dated 7th day of July 2022, purporting to reinstate the applicant, shows that the respondent is unwilling to obey the clear and unambiguous order of this honorable court. Counsel asked the court to discountenance the respondent counter affidavit and argument thereto and grant the application and punish the contemnors accordingly. Court decision: I have carefully considered the processes filed as well as the argument canvassed by parties for and against this application. The application under consideration is a post-judgment application seeking to commit the party cited as contemnous in accordance with the provision of Order 63, Rule 1, 2 of the National Industrial Code Civil Procedure Rules 2017 and Order 9, Rule 13, Sub-Rule 1 of the Judgment Enforcement Rules. It is the submission of learned counsel for the judgment credit to applicant that the order of the court as contained in its judgment, Exhibit A, is very clear and unambiguous and directing the judgment debtors to restore the name of the claimant back to the payroll and pay him his arrears of salaries. But the judgment debtors have, despite being served with Exhibit A, decide and from 48 and 49 fail and refuse to obey the said order. Counsel insisted that the judgment debtors has proper notice of the terms of the order as same was served on them by the judgment creditors applicants counsel through letters written to them, and also counsel also relied on Order 63 and urged the court to grant the application and punish the judgment debtors for contempt. For the counsel for the judgment debtors respondent, the court has not made any order against such the respondent which he disobeyed and rendered himself liable to committal for contempt. Counsel also argued that the committal proceeding is quasi-criminal in nature. Compliance with procedure and law are compulsory as any slightest wrongful step taken will vitiate the same proceeding. According to counsel, the present proceeding is incompetent due to non-compliance with condition precedent, i.e. personal service on the. It is also position of counsel for the judgment debtors that have regard to Exhibit MOJ1, which was served on the applicant through the chairman secondary school education board. The applicant has been reinstated as ordered by the court. Having quoted the argument and the submissions, counsel for both the issue that first need to be resolved is whether indeed the parties sought to be committed for contempt have been duly served the required processes, i.e. forms 48 and 49. The judgment debtors respondent have in paragraph 4 of the counter affidavit stated that they have not been personally served with form 48 and 49. They have also stated that by Exhibit MOJ1, the applicant has been reinstated as ordered by the court. What remains is payment of his arrears of salaries to follow. In reaction, the applicant had insisted that the judgment debtors respondent have been duly served with the judgment of the court, Exhibit A and Form 48 and 49 by the bailiff of the court. The applicant has also denied ever been reinstated as being served with as he has not been served with Exhibit MOJ1. Contempt being quasi-criminal charge, the burden of proving it is on the applicant, and he must prove the allegation contained in the affidavit in support of the application for contempt beyond a reasonable doubt. See the case of Onagorua versus Adeniji. Since contempt proceeding affect the liberty of the individual, the law expects strict compliance with the procedural rules. See the case of LZG versus Ike. A committal proceedings by its nature is a legal enforcement mechanism used to mandate the compliance of a valid existing and enforceable order, undertaking, or directives of the court. Therefore, the foundation for any criminal proceeding is a disobedience of a valid existence and enforceable order of the court. There is no doubt that Exhibit A is a valid existing order of the court, which must be complied with by all concerned. Therefore, refusal or neglecting to comply with the said order will attract sanction from the court. For the court to enforce the sanction of committal there must be sufficient proof or due compliance with the provisions on part with the procedure on part of the applicant. See the case of Alhaji Lawal Lagu versus Attorney General of Katsina State and another. It is appropriate here to examine the provisions of the rules of this court and the provisions of the judgment enforcement rules to which the applicant relies in making this application to see whether the motion for committal is properly before the court in view of the respondent's claim of non-service of Form 48, non-personal service of Forms 48 and 49 on them. Order 63, Rule 1 read, an application for an order for committal may be made to the court by any of the parties in an action before the court by motion on notice, which shall be supported by an affidavit and shall state the grounds of the application, accompanied with a copy of judgment or order or direction of the court, which is the subject of content procedure, with a written address giving sufficient and compelling reasons for necessitating the contempt proceeding. 2, the motion on notice, affidavit, and ground shall be served personally on the person or on counsel to the person or on any principal officer of the body sought to be committed. But the court may dispense with personal service where the justice of the case so demand. 6, where the contemptor is not a natural person, the court or the applicant shall seek leave of the court to proceed against any of the principal officers of the contemptor or against the chief executive officer, managing director, the company secretary, or the other responsible, or any other person responsible and highly placed officer of the contemptor. While Order 9, Rule 13, Rule 1 of the Judgment Enforcement Rules made pursuant to Section 94 of the Sheriff and Civil Process Act read as follows: when an order enforceable by committal under Section 72 of the Act has been made, the registrar shall, if order was made in absence of the judgment debtor and is for the delivery of goods without option of paying their value or in the nature of an injunction at the time once the order is drawn up, and in any other case on the application of the judgment creditor, issue a copy of the order endorsed with a notice as in Form 48, and the copy of the order should be served on the judgment debtors like in the like manner as judgment summons. Order 9, Rule 1 of the Judgment Enforcement Rule read: a judgment summons shall be served personally in accordance with the rules for personal service of an ordinary summons issued for the court for which the judgment summons is issued. The provisions of Order 3 of the National Industrial Court rules quoted above and the provisions of Order 9, Rule 13 of the Judgment Enforcement Rules also quoted above are very clear and unambiguous. The provisions must be obeyed in commencing content proceeding. The respondents have positively in their affidavit evidence about that they were never served with Form 48 and 49 as required by law. The affidavit evidence is very crucial. The evidence therein is to the effect that the judgment debtor have not been served with the Form 48 and 49, which are required to be served on them by law. The reaction of the applicant is that they had been served by his counsel and the bailiff of the court. I have searched the case file. There was no affidavit of service showing that service of Form 48 and 49 have been effected on the judgment debtors. The only evidence in the case file showing some semblance of service shows that Form 48 meant for service on the case respondent was served on the 16th day of September 2022 on one Bessie Benjamin for the second one Bessie Benjamin, and for that of the second respondent Form 48 was served served on anybody. There was no indication that it was served. For the third respondent, he was served through one H. John, a staff of the Ministry of Justice. For Form 49, it was said to have been received by one Ekanem Nicholas, Office of the Head of Service. One Ede Bobby was said to have received Form 49 for the Office of Accountant General, and Uket Lawrence was said to have been the one that received Form 49 for the third respondent. It is to be noted that the document Form 48 and 49 were said to have been received by persons other than the person to which the forms were meant for. This has gone to establish that the persons cited for contempt were not personally served with Form 48 and 49. This which case was relied by all the parties in this suit. The non-personal service of Form 48 and 49 clearly is a contravention of the clear and unambiguous provisions of Order 9, Rule 13 of the Judgment Enforcement Rules, which provides that the Form 48 should be served in the manner as a judgment summons in accordance with Order 9, Rule 5. Judgment Enforcement Rules shall service of judgment summons shall be personally be done. The operative words in Order 9 of Rule 5, Sub Rule 1 is shall, which in Kalamu versus Guru was said to be compulsory. It is no longer in doubt that the word shall, when used in a statute or rule of court, made it mandatory that the rule must be obeyed. In other words, generally the term shall is a word of command and denotes obligation, and thus give no room to discretion. It imposes a duty to act in the way and manner provided by the rules. Since contempt proceedings affect the liberty of individuals, the law expects strict compliance with procedural rules. Therefore, where there is slightest deviation or non-compliance with the rules, a court of law must exercise its discretion in favor of the contempt law. This is because the law cannot gamble with the liberty of the individual in the procedure relating to contempt or of the order of court. Any irregularity, no matter how impeachable it is in the procedure for committal, is fundamental bias, which vitiates the entire application. It is patently clear from the above provisions governing this application that Form 48 must be served personally on the persons sought to be committed. However, in appropriate circumstances, the court may dispense with personal service where justice of the case demand. In this case, the court has not dispensed with the personal service, as no such request was made to it by the counsel for the applicant. Consequently, the condition precedent for exercise of jurisdiction has not been met. See the case of Madukolo versus Inkendilim. See also Aina versus Jinadu. See also Ohumo Gogo versus Okoji. See also Chuku and others versus Chuku and others. It is after issuance and service of Form 48 and 49 that the motion for committal can be brought before the court. Having not done that in this case, the motion is incompetent. See the case of Basil Okomo versus Sunday Samuel Udo. It is to be noted that service by counsel is not recognized as proper service under the rules. Likewise, the service, purported service by the bailiff was shown to have been served on different persons who are not the contemnors. In the circumstances, it cannot be said that the contemnors were personally served with Form 48 and 49. The counsel for the applicant has also in his argument submitted that the contemnors are artificial persons. So if that is true, by Order 63 of the rules of this court, which allows, which is one of the order relied by the applicant to make this application, an artificial person cannot be proceeded except with the leave of the court, and no such leave has been obtained. From all I have been saying above, the application of the claimants as it is presently constituted is incompetent due to non-compliance with the laid down procedure as enumerated in Order 63 of the rules of this court and Order 9, Rule 13, Sub 1 of the Judgment Enforcement Procedure Rules. The motion for committal is defective and incompetent. It is hereby struck out.
My Lord, we are very grateful. We commend my Lord.
You are on to when it comes, maybe it will have the same effect, it will have the same fate. Eh? You are a claimant in one of the matters here. Yeah. Okay. Mr. Osang, I think I have told you committal proceeding. You know the mistake counsel made is they will write letters. That cannot suffice. That is not proper service as per the judgment enforcement. They say it should be served as summons, and summons demand that it should be served personally. So you have to serve personally. And if according to you, you say these people they are artificial persons, then you need the leave of the court before you can go after them. You need leave of court. I don't know why you people are even wasting time going for contempt. What you should have done, file mandamus, compel them. They are public officers, compel them to obey the order of the court. That would have been the easiest way.
Before my Lord rise.
Counsel, I have already adjourned that matter. It is your fault.
My Lord, I didn't get the date. My network was bad.
6, which day is that? Registrar.
My Lord, the defense counsel actually proposed a date.
6 what?
July, my Lord.
It has been adjourned to 6 July.
My Lord, the defense counsel actually proposed a date. My network was bad.
Which day did he propose?
He proposed 13th of June. I think the defense counsel is in court. Is before you physically.
If he is in court, I have so many cases. It depends
no, it's
on
before you physically.
I say it depends on the convenience of the court, not your
as
own
a court
convenience.
pleases.
I have so many cases on that day. I can't accommodate you on 13th of June. Come back on 6th of July.
As the court pleases. Thank you, my Lord.
You are welcome.
And have a fantastic court session.
Thank you. Thank you very much. You are free to go. I want to see whether I have written that ruling. I don't know why.